Good evening. Hello, how are you? We're here live with this adjustment of status session. Yes, we're waiting for people to join us so that we can get started. Once you're here, just say a hi in the comment and let me know, please, where you are actually watching me from. If you are in New York, say New York City. I mean, depending on where you are exactly in New York. If you're here in Baltimore, say hi from Baltimore. If you're in the DC area, say hi. If you're in Virginia, say hi. Yes, we're going to talk about this adjustment of status this entire week. And I'm going to give you some tips too on expedite requests with the board of appeal, right? Immigration board of appeal. I'll give you some tips when it comes to expediting your case with them, okay? And immigration court, of course, EOIR. So if you're here, I see 5 people already here. Please, let's go ahead and like. Let's go ahead and share. Let's start commenting so we can get this video um, be shown to other people. Yeah, please go ahead and let me know in the comments, okay? If you have a question about adjustment of status, this is the time to ask your question. If you need a consultation with me, consultation links are in the description box um, below. Yes, you can email me too. I can send you the consultation link. It's right there on the screen. Yes, Pat Vansobia. Hi, how are you? Where are you watching me from? Say what city? Anyway, so we're gonna get started. I'm gonna share my screen, but in the meantime, if you have a question, just put it in the comments so we can get started, okay? We're gonna talk about 2 things here. We're gonna talk about adjustment of status under the matter of Quilantan. Then we're gonna talk about expedite requests with the immigration court or the Immigration Board of Appeal, BIA. Oh, from Rochester. Yes, how are you? I'm glad I'm glad you're here. Let me share the screen so we can start. Okay? So let me share the screen so we can start. Share the screen. Yeah, we're gonna start with this matter of Gracilia Quilantan. Okay, and that was decided on July 28, 2010. Okay, so and this one is really good for people with entry without inspection, but as far as I'm concerned, this one is specifically with people with entry through wave, like the officer wave you through, right? So that's what happened with this Quilantan. Okay, so pretty much Quilantan, okay, is a native of Mexico who entered the United States the first time in 1993 using a valid border crossing card. She remained without departure until December 2000. Okay, she entered 1993. She stayed until 2000. Then she returned to Mexico to visit family members. Okay, at some point between 1993 and 2000, she lost her border crossing card. She lost it. Okay. And then in January 2001, she applied for a United States visitor visa at the consulate in Mexico, but her application was denied. Okay. A few days later, on January 10, 2001, without a valid document to enter, she approached the border as a passenger. You see, passenger in a car being driven by her United States citizen friend. So basically, she was in the car where a United States citizen friend was driving. According to her, the immigration inspector, basically the officer at the border, CBP, asked her friend whether he was an American citizen, but did not ask her anything. She was the passenger. They asked the driver, "Are you a U.S. citizen?" The driver said, "Yes, I'm a U.S. citizen." And the officer just waved them through. Okay, this is the key word here: wave the car through the port of entry. So she was waved through the United States. So they did not inspect her. They did not ask her anything. They did not officially admitted her, but they waved her through. Okay. So, and then later on, she married a U.S. citizen in January 2006. And her visa, immediate relative visa petition, which was approved, then she wanted to appear. She wanted to adjust status. And when because she had a notice to appear, then she went to court and tried to adjust status. The case was denied. That's when she appealed. The case was denied basically because they were saying that she was not admitted to the United States into without inspection. She was not paroled, so she did not have any valid document that permits entry or parole. So that was the reason her green card application was denied. So then she appealed the decision, right? So when she appealed the decision with the BIA, now the issue here was, what was the issue? The issue was to determine if she's eligible for adjustment of status. Then the court said that they must decide whether she was inspected and admitted to the United States. And to do so, the court decided that whether she needs only show procedural regularity in her entry to establish that she was admitted, or whether she must prove compliance with substantive legal requirement. So it was the problem of procedurally or substantively. Basically, what they're trying to say that, well, is she supposed to show the document, or the fact that the officer waved her through, it must be considered as basically admission. So, and the court decided that it was admission. Okay. On appeal, both parties agreed to the term admitted under Section 245A of the Act demands only procedural regularity in an entry, not compliance with substantive legal requirement. And they urge us to adopt that interpretation. So that's why this lady was able to adjust status, because she was able to prove that although she had no paperwork, no official document, nothing, but the fact that she was a passenger in the car and the officer waved them through, it must be considered as admission, and she won. So that's why some people can adjust status under Quilantan. That's what I wanted to say. So basically, the conclusion was that the respondent, which is Quintilan, made a lawful entry into the United States after inspection and authorization by an immigration officer within the meaning of the section of the act, and that she is not removable. Furthermore, because the respondent was admitted to the United States, she's eligible for adjustment of status under 245A of the act. So that's how she was able to adjust status. Okay, we're going to talk about it. Let me stop sharing for a minute. So that's the reason why this respondent was able to adjust status. So basically, I keep telling people there are uncommon ways. When people make their entry in the United States, sometimes some people have false documents. That is misrepresentation. But the fact that they just enter with false documents, they might need a waiver later on, but it is admission because they were admitted under false pretenses, of course, but they were admitted. So those type of people, that category, they need um, a waiver later on in the process, the waiver of willful misrepresentation. But this type, like Quilantan, they don't need it, because if the officer waved through the car, you don't need it. You just have to show some proof that you were in that specific car. Sometimes it's in the bus. Yes, Gonzalez. Please share. Thank you, Gonzalez. Let's tell this, my people, please share and like the video. Come on, 7 people already. Please share and like the video, because this is important information. It can help somebody. So anyway, I was saying that Quilantan, like anybody else who comes to the bus, and then they just, if they don't verify your document, it means that they waive you through. So you can claim that you were admitted as long as you can prove it, that you were in that specific bus, you bought the ticket, the officer didn't check you out, and you got admitted in the United States. So you can actually adjust status later on. From DC, hi Gonzalez from DC. Nice to, thank you for coming back. So you need to bring your friends too. Like this is, we're gonna be here this entire week talking about adjustment of status. You need to bring your friends too. So this is what I wanted to share with you, this Quilantan, the matter of Quilantan, and that's how some people can adjust status under 245A, even though that they cannot show that they had a valid passport to get in the US, but the simple fact that the officer waved them through because they happen to be a passenger in a car, they happen to be a passenger in a bus, yes, they can adjust status later on if they marry a US citizen, or under employment base if their unlawful presence is less than 180 days, or if they meet the exceptions under 245I, yes, they can adjust status. Those who enter with a false document, however, it is misrepresentation, but you can always waive it, because those other people, when they get with somebody else's document or misrepresenting facts, most of the time they apply for asylum. And that's how they're able to even get asylum granted, even though they enter with false document. It's because they can prove that they were actually running away from their country. And some will apply for a waiver of willful misrepresentation, and sometimes that waiver gets granted as well. So, my friend, if you need to actually adjust status under the matter of Quilantan, and you can prove that you were waived through, we can help you do that. Okay, we can really help you do that. My consultation links are in the description box. If you have a question in the meantime, please drop it in the comment. And we got 9 people watching us. Please let me know in the comments, where are you located, what city, so we can holler back to you. You can like too. Please like and share. I appreciate when you like and share. Okay. Then we're gonna go to the second topic. I wanted to share with you, because people have asked me this question: how long does it take for the BIA to respond to a motion or to a case? We don't have a specific answer for that. The reason being is because of the backlog. While BIA can take between 2 weeks to 4 years. I've seen cases pending with BIA for 4 years. I've seen cases pending for 2 weeks only, 13 days. So in between that, BIA will eventually respond to you. But what can you do to expedite their response? That's exactly what I'm going to share with you today, because sometimes people say, well, there's nothing I can do with BIA. Well, there's always something you can try, okay? Whether it is with immigration court or the Board of Immigration Appeal. So there's always something you can try. We're going to talk about expedite requests with BIA. Okay, let me share my screen again. Yeah, just give me one moment. I'm going to share my screen again. Okay. Yeah, this is, let me put it big. Okay. So this is expedite request with who? With BIA, right? The BIA practice manual, right? The Board of Immigration Appeal. Can you expedite your case? Can you expedite? Yes, you can do that. You can expedite an appeal, or you can expedite whatever motion that has been filed with BIA. But what you need to do, you need to file a motion to expedite, and you need to demonstrate impending and irreparable harm or similar good cause. You have to be able to demonstrate why they need to expedite your case, because we know they have at least 2 million of cases pending with BIA, with the immigration court system in general. So why they have to expedite your case? Okay, so yes, you can expedite the case. Those are the reasons, right? Expedite requests are generally not favorable and should be requested only in compelling circumstances. You see, has to be something extreme, compelling circumstances. What are the examples? Okay, it might include imminent removal from the United States. Okay, imminent ineligibility for relief, such as a minor aging out or a derivative status. So let me give you a specific example for this one. For example, we have this current agreement with USCIS where TPS holders who actually travel, who initially enter without inspection, they later on travel outside of the United States, and now made the second entry, which is lawful entry, and the one I just status, but because they have previous order of removal, they couldn't. So USCIS made an agreement with ICE to join motion so that they can reopen their case, right? But remember that they have a cutoff date sometime in January 2025. So if we are approaching that date and BIA hasn't responded to the motion to terminate or to dismiss the case, then we can say that yes, imminent eligibility for relief. Like we can show the Board of Immigration Appeal that, well, you need to respond now, because if you don't do that, this agreement with that USCIS has with ICE is going to expire. Okay, you can do that. In those type of circumstances, you can try to expedite your motion or your appeal. If we have a minor that will age out in terms of getting some type of benefit under either asylum status or anything else, yes, you can expedite your appeal. Okay, derivative status, aging out of derivative status, like this is a specific example will be asylum, right? So under circumstances threatening to moot the appeal, yes, if something like what I said, if something that comes up that is going to make this case moot, which means that the case will not, the law will no longer have effect on that case, then you can expedite. Okay, health crisis precipitating a need for immediate board action. Somebody has a problem like a health. We have clients where they have to go to organ transplant, and if they get some type of status, it's going to help them to get that type of organ. Okay, and those are the people who can claim that expedite request. They will say, well, yes, we really need you to decide on my case, because if this benefit is granted to me because of my health situation or my disease, then I can be able to get some type of help or medical care. Without legal status, I cannot, based on I don't have the money for insurance and stuff like that. Those are the compelling circumstances where BIA can, in fact, agree to expedite your case. Okay, and here just give you procedure on how to file it, and then how do you get the response? Look at what BIA is saying. BIA is saying that the board will consider all expedite requests that are properly filed. It has to be properly filed, meaning that you have to follow the procedures, okay? And when the request is granted, the board will expedite the case without notifying the party that the request has been granted. They're not even going to tell you that we have granted the request. They're just going to expedite the case and do it. You can see maybe after sending your expedite request, maybe 2 weeks later or 3 weeks later, they decide on your case, something around those lines. For administrative reason, the board cannot reply to all requests, you see. But it's something worth trying if you've been waiting for too long and you have compelling circumstances. Because people always call me like, oh, it's taking too long, it's taking too long. Well, if you cannot wait and you have compelling circumstances such as those listed here, yes, then try by all means expedite your case with BIA. And if you are in immigration court, the way it works, and the hearing is like in two years from now, you can file a motion to advance hearing to put the date a little bit closer, okay? But still have to have good cause. So I wanted to share that because a lot of people have been talking to me about how long it's going to take with BIA, how long it takes, as long as it's going to take. So if you don't have those compelling circumstances to expedite your case, then just wait. You can follow through calling them, but patience is required, right? In case you cannot expedite it, okay? So we understand that you want to get the answer, but patience is required if you don't have compelling circumstances to expedite the case. And remember that you cannot just file any meritless motion with the court, okay? Any frivolous motion with the court is a big no. So you really have to have compelling circumstances. So, yeah, and follow procedure in order for BIA to consider your expedite request. So when it comes to immigration court, then we have what they call motion to advance. If the case has been set for a later date, you can advance it by filing a motion to advance, okay? And again, you have to show good cause for anything that you do. So this is it for today. Now I'm gonna take questions. Yes, do you guys have questions? Okay. Gonzalez is saying, what is BIA? BIA is the Board of Immigration Appeal. Like, let's say somebody goes to immigration court, the case gets denied, then they file an appeal with Board of Immigration Appeal. So basically, it's a upper level when it comes to immigration, okay? Let's get into this one. Pete Van, I think Pete Van, we already answered your question. Let's see if it's a different question. Came on F1 visa, applied for asylum, and case was referred to immigration court. Case was removed from court calendar, and now my work applied for I-140. Any chance of adjusting status? Only if you fell into the exceptions. 245I, we talked about it yesterday. Yeah, only if you fell into those exceptions of 245I. As far as employment is concerned, the very fact that they sent your case to immigration courts, it simply means that you overstay your visa. So, and I'm pretty sure you have more than 6 months of unlawful presence. So if you don't have 245I as an exception, then it's not going to work. We have 11 people. Please go ahead and share. Please go ahead and like. Estimated time after being approved, approximately 2 weeks. Yeah, I see a lot of 2 weeks. Then you have your green card. Usually you can check your status online. Pretty. You can check your status online. It's going to say case has been approved, card have been ordered to be produced. Then it's going to change to the card has been produced, and then it has been shipped. Yeah, keep checking online. I would say 2 weeks from my personal experience. Yes, we got 10 people here. Please go ahead and share. Please go ahead and like. We got 10 people here. Please go ahead and share. Please go ahead and like. And if you have a question, just put it in the comment. I want to see how many people are actually liking so I can either stop or continue, right? But in the meantime, if you have a question, just put it in the comment. And if you need a consultation, yes, you can schedule it by using the link in the description box below. Pete Van Sobia, you have to watch my video from yesterday, actually, 245i. And if you feel like you meet those exceptions, then the answer will be yes. You can adjust status. If not, then you cannot. If you don't know how to find out whether you meet those exceptions, you can always schedule a consultation. Okay. Yeah, pretty, you need to call them. If you have been approved by USCIS, you need to call them and find out where is your green card. But if you've been approved by immigration court, you need to go to the field office. You need to watch my video from yesterday anyway. So you need to set up an appointment online and go to the field office so you can get your I-94. If it's an approval from the judge. But if it's from USCIS, you need to call them and find out where's my green card, because that's what everybody's waiting, right? So you got approved a month ago and you don't have the green card in your hands. That's strange. You need to call them. Call them and find out, okay? Let me check if I have how many people are actually liking my videos, okay? Because you guys need to be sharing, because this is pretty good information. Very good information, okay? Let me check. Yeah, we've only got 6 likes. Come on, folks. You can do better. You can do better than that. We got 10 people here and we only have 6 likes. Come on, go ahead. Pretty, please go ahead and like, okay? We need 4 more likes to match the number of people we have on this live session. Yes, you're welcome. So, anybody else has a question? Well, if we don't have questions, in 3 minutes, I'm gonna end this conversation so that I can rest. But I'll be here tomorrow. We're gonna talk about some other stuff. It's all about adjustment of status, because we really want to dedicate this week to help somebody adjust their status so they can get lawful permanent residency and be able to travel outside of this country, because people didn't just come here to stay forever, you know. So that's the goal. That's our goal. That's our mission. We're gonna get it sooner or later. We're gonna get it. So that's why we are trying to provide as much information as we can so that we can help somebody here. 9 people. Please go ahead and like and share. If you have a question, please put it in the comment. I don't see any question. In 2 minutes, if I don't see any other question, I'm just gonna hang up, because you know, time is valuable. We do appreciate you two coming here, but if there's no more question, there's no point to hold you here, because time is valuable, okay? Pit Van, you can argue, right? You can argue technicality. You can argue for technical reasons. I didn't overstay my visa. But the fact that somebody applied for asylum is not a status. Just remember that asylum is not a status, okay? So the argument can go both ways. You can say, well, I did not overstay my visa because I was I apply for asylum, but asylum is not a status until it is granted. So that's the argument of the USCIS. You can argue technical reasons and hope for the best, but I can tell you from the fact that somebody was put in removal proceedings based on the asylum, it just means that they overstayed their visa, because asylum is not a status. The moment you get out of the F1 visa and you are on asylum pending, it's not a status. When we were talking about yesterday about this guy, So he was dealing with USCIS, remember? And he had to go all the way to the Ninth Circuit Court to convince them. So you might have to do that, because USCIS on the spot, they're not just going to grant you that, because they're going to say overstay. Asylum is not a status. Pete Van Sobaya, you really need a consultation, but you just don't want to do it. You need a consultation so we can guide you, okay? We can give you some tips, some arguments, some clue, some techniques. That's what we are here for. Yeah, please schedule a consultation, and especially you doing nurse. Yeah, you got a lot to show, okay? A lot of things to actually, you got a lot of arguments you can give to them, but you need a consultation. I'm telling you, you need to schedule it. Consultation link is in the description box. So it's better to have guidance and do it right the first time, instead of going all the way till the Ninth Circuit or whatever circuit. I don't know where you are from. But yeah, so that's my answer for that. 7 people. Anybody else? Anybody else has a question? I think the only people who had a question here is Pete Van Sobay, Pretty Gonzalez is in DC. Gonzalez, if you're in DC, it's always nice. If you need a lawyer in DC, I am in DC, okay? Always nice to either recommend your friends or refer your friends to me, because I'm in the DC metropolitan area. So it's better to have somebody who's close here if you need one, of course. If your friends need one, family member, yes, you need to recommend somebody who's close. Okay? Yeah. Anyway, we'll come back again tomorrow with another topic on adjustment of status. And hopefully we're going to cover not everything, but most important things on adjustment of status, because it has a lot of nuances, because you still have to be eligible in terms of unlawful presence is just one element. You still have to be eligible in terms of public charge, admissibility, inadmissibility issues such as public charge, communicable diseases, criminal offenses, and stuff like that. So there are a lot of yeah, we're almost done. African Nation United, we are almost done. As long as I just you watch from the beginning, because we're really done. We were just talking about adjustment of status and some nuances. Yeah, it's better to watch it from the beginning, because we are pretty much done. And we talked about giving some people some tips on expedited requests with BIA, the Board of Immigration Appeal. Yeah, so adjustment of status is our main thing. We're just giving some exceptions and so forth. Yeah, strongly suggest you start from the beginning. Then you will have an idea of what we're talking about. But in short, adjustment of status is the topic. Okay, so what else is there to say? Anybody else has a question? We can move on, or we can hang up. I guess not. Nobody else has a question, so I think we're gonna have to hang up for today, right? So you can join us again tomorrow, 6 p.m. Eastern time, okay? We'll be here tomorrow, Thursday, the 24th, and we'll be here Friday, the 25th to wrap it up. So if you missed today, you can come back tomorrow, bring your friends, family members, etc., etc. And please like and share. That's the main goal here. Like and share, especially the sharing thing. It's going to help somebody. You never know who you're going to help. Okay? Thank you very much. I appreciate your time. Thank you for joining. Until next time, bye-bye.